Mary Bauman is an attorney at Miller Johnson in Grand Rapids, Michigan. She works with employers in establishing, amending, and terminating employee benefit plans of all types. Ms. Bauman is the chair of the firm's Employee Benefits and Executive Compensation Practice Group and leads the healthcare reform team. Ms. Bauman is recommended by Chambers USA for employee benefits and executive compensation and is listed in the best lawyers in America for employee benefits law. Other significant honors include being recognized as a Michigan super lawyer, a client service all-star by BTI Consulting, most influential woman by the Grand Rapids Business Journal, and a woman in the law by Michigan Lawyers Weekly. And with that, I'd like to turn the presentation over to Mary, and hope we learned something this morning.
David, thank you so much, and good morning, everyone. Glad you have joined us. We are going to try to make this as simple and clear as possible, and we know that this is complicated stuff, so hang with me on this. Our focus today is measuring for the pay-or-play penalty under the Affordable Care Act. So that's our focus for today. So before we get started in actually applying and measuring for the penalty, we want to know who we're talking about. And who we're talking about is large employers. And a large employer is an employer with at least 50 full-time employees and full-time employee equivalents in the previous year. And this is made on a calendar year basis. So for example, and it's based upon the average number of full-time employees and full-time employee equivalents in the prior year. So for example, for 2015, you're looking back at 2014. In general, you're going to be looking at all 12 months of the prior calendar year in terms of your average, but for 2015 and 2015 only, if you want to use a 6-month snapshot in 2015, you can do that. But in general, you are looking at the entire prior calendar year to determine if you are a large employer for the following calendar year. And so for this purpose, we're saying how many full-time employees do we have who work 30 or more hours a week, and then we add to that for every month the number of non-full-time employees, and we add up all their hours and we divide by 120, and that gets us to a full-time employee equivalency number. We add those two numbers together for every single month. We add up all the months, and then we divide by 12, and that gets us our average. So it's kind of complicated, but if you are an employer on the call today who is what I call on the bubble, this is an analysis that you're going to want to do every single year to determine whether you're a large employer or not for purposes of the pay or play. I should also mention that if you are part of what we call a controlled group, and that is a defined term under Section 414 of the Internal Revenue Code, if you are commonly owned within the meaning of 414, then the different businesses in your control group are aggregated together to determine whether or not you're a large employer. So for example, you might be a company with 20 employees, but if you are a subsidiary of a parent corporation with 60 employees, you are considered to be a large employer for purposes of the pay or play, even though you only have 20 employees working for your taxpayer ID number. Now, having said all of this and focusing on the number 50, we will in a few minutes talk about the mid-size employer relief for the first year. Now, you may recall that the pay or play was supposed to take effect in 2014, but right around the July 4 holiday in 2013, the IRS said it would push back the effective date for 1 year until 2015. Now, there are two different penalties under the pay or play. I call this first one the death penalty because it is a much more serious consequence than the second penalty, the $3,000 penalty. So even though $2,000 sounds like it doesn't cost as much, it's actually the worst penalty of the two. So under the $2,000 penalty, if I'm a large employer, 50 or more full-time employees and full-time employee equivalents, and I don't offer coverage to at least 95% of my full-time employees and their dependent children. And by the way, for this purpose, I can back out those full-time employee equivalents. I don't have to offer them coverage at the 95% level. But if I don't offer coverage to at least 95% of my full-timers and their children, and at least one of them is low income and goes to the exchange and gets a premium credit, I have to pay a penalty of $2,000 per year multiplied by all of my full-time employees, even if I offer them coverage. I can disregard, though, the first 30 from that calculation. So let's say I have 200 employees. I only offer coverage to 180 of them. I flunk the 95% test. I can back out the first 30, so I'm only paying the $2,000 penalty essentially on 170 of my full-timers rather than all 200 of them. Now, as you'll notice here, the requirement is that you provide, or offer, I should say, coverage to at least 95% of your full-time employees and their dependent children. Dependent children for this purpose includes your natural-born children and your adopted children. You don't have to provide children to other categories, health coverage to other categories of children, such as foster children, grandchildren, etc. Those are optional. You can do that if you want, but you don't have to. And for this purpose, you have to provide coverage until the end of the month the child attains age 26. Now, you may stop and say to yourself, gee, Mary, when healthcare reform was first enacted, I thought they only required me to provide coverage until the child's 26th birthday. You are absolutely right in your recollection of that. But for purposes of avoiding the pay or play, you now have to go until the end of the month the child attains age 26. Now, the good news is that there has been transition relief made available, so as long as you're taking steps to move in that direction, you're all set on that, provided that you amend your plan by no later than the first day of your 2016 plan year to provide for coverage until the end of the month the child attains age 26. Now, for this purpose, full-time employees include the full-time employees who you think, right? I mean, the people that you regularly schedule to work 30 or more hours a week. But it also includes leased employees through a temporary staffing agency, and I'm going to talk a little bit more about that later. And it also includes anyone who is part-time that you classify as part-time, but they actually work 30 or more hours a week during a measurement period, and we're going to talk about that too. So I call those misclassified part-timers. And then it would also include folks that you might characterize as an independent contractor, so you could exclude them, but if you don't classify them properly and they really are your employees, they could be counted for purposes of the 95% threshold. So it's really important to make sure that you're classifying all your workers properly when you conduct this particular test. Now, I thought I would just take a little time out here to talk about independent contractors. This is an area that I think a lot of employers have not paid as close attention to as they should. And now with the Affordable Care Act and the pay or play penalty, I really think there's heightened importance and significance to this. So in order for someone to be an independent contractor as opposed to your employee, and again, if they're truly an independent contractor, they're not your problem for purposes of the pay or play. But the key is, are they truly your employee? Well, in order for them to not be your employee and to be an independent contractor, they can't be subject to your direction and control. They are their own person. And here's some of the factors to make that determination, and this is prescribed by the IRS. One of the things that they look at is, what kind of work is this person engaged in? Is it a distinct type of occupation or business as opposed to your core business? So, for example, maybe your core business is manufacturing, and this person is hired as an IT specialist, and that person's going to come in and work with you on your computer system. It's very possible that they might be engaged as an independent contractor. On the other hand, if you're hiring them as really an independent contractor, but they're managing your plant, that's probably not going to fly. The other factor is the kind of occupation and whether the work is usually done under the direction and control of the employer, or it's done by a specialist without any supervision. Can they work on their own? Another is the kind of skills required. The more highly skilled the person is, the more likely they are to be eligible to be treated as an independent contractor. Other factors include whether they supply their own tools or equipment, the length of time that they're employed. The longer the period, the less likely they are an independent contractor. Whether the person is paid by the hour or the job. If they're paid by the hour, it's less likely they're an independent contractor. Again, whether the work is part of your regular business, and whether the parties believe they are creating an employment relationship. So those are some of the factors that the IRS would look at for purposes of determining whether they are your employee or your independent contractor. So make sure that you're careful when you make those determinations, because it has a ripple effect on the pay or play penalty. So now we're going to go to the second penalty, which, as I said, is a higher dollar amount, $3,000, but it really doesn't have as big of an impact. Here's a situation where you do offer coverage to at least 95% of your full-timers, but the coverage that you offer either isn't affordable or it's not of minimum value, or maybe both. And in that situation, a low-income full-timer doesn't enroll in your coverage. They go to the exchange and receive a premium credit, and for the purposes of this penalty, you would be paying the $3,000 annually for each such worker. So only the people that actually go to the exchange, enroll in coverage there, and get the premium credit. So this is going to be a much smaller number of people than would be, for example, under the $2,000 penalty, which looks at your entire full-time workforce. So in terms of applying the $3,000 penalty, we have to look at those two terms, affordability and minimum value. Affordability means that the employee's required contribution, the premium that they are required to pay for single coverage under the employer's least expensive medical option, does not exceed 9.5% of the employee's pay. And you'll notice I say single coverage. That's because the cost of dependent coverage for the spouse and children is disregarded under the affordability test. There are three different, and by the way, that is not expected to change. They would have to amend the law for that to change. There are three different safe harbor methods to determine affordability. One is known as the W-2 method, the second is the rate of pay method, and the third is the federal poverty line method. So first, let's talk about the W-2 safe harbor. Under this safe harbor, what we do is we look at the person's annual premium for the year. How much does that worker have to pay for single employee coverage under your cheapest medical option? And when I say medical, I don't mean dental and vision. I mean really your medical option. And does that exceed 9.5% of the employee's wages for that year under box 1 on the form W-2? So one of the challenges of this method is, so for 2015, for example, in terms of affordability, we won't know what that figure is until January of 2016 when we have our W-2 forms prepared and we look at box 1. Now we can guesstimate that and kind of monitor that throughout 2015, but that is really going to be something that we're throwing a little bit of a dart on a dartboard. And also remember that any pre-tax contributions that the employee would make, for example, to his or her 401k plan or toward the cost of health coverage under your plan would reduce that box 1 number. So for those reasons, I have a lot of clients that are not super excited about using the W-2 safe harbor method. The second method is known as the rate of pay. This one is a little bit more straightforward, but it has some downsides too. Under this method, what we say is we look at the person's monthly required contributions for a month, and we compare that to 9.5% of his or her monthly pay. And if the person is paid on an hourly basis, what we do is we look at their hourly rate at the beginning of the plan year, and we multiply that by 130, and that gets us to their monthly rate of pay, and that's what we compare 9.5% of that to the monthly required employee contribution. And the positive of this method is certainty, the downside, and that you know it at the beginning of the year. But the downside is, of course, you'll see for an hourly worker that we're only multiplying that by 130, which is basically designed to approximate a 30-hour work week over a month. So in other words, if this person works like 40-plus hours a week, you're not going to be able to take advantage of that in this rate of pay affordability safe harbor. And there's also a similar safe harbor available for salaried workers, and you're looking at their monthly base salary at the beginning of the year. Now, a couple other little things to note here. If the person is hourly and their rate of pay decreases during the year, then you have to adjust the rate of pay for those subsequent months to reflect their lower rate. And if the person is salaried and they have a pay cut during the year, then you can't use this safe harbor. And then the final safe harbor is, I would say, the easiest and most straightforward to use, but it probably results in the lowest amount in terms of affordability. Under the federal poverty line safe harbor, the third safe harbor, what we do is we compare what the employee has to pay for single coverage under your cheapest plan to 9.5% of the federal poverty line for a single person household. And basically that would allow you to charge an employee a little more than $92 a month and still have the coverage be affordable. That may be a lower amount. That's probably for somebody that's making like $11,000 a year or less. Is good. That would be a desirable safe harbor. But for people that make $15,000 a year, $18,000, $20,000 a year, one of those other methods is likely to result in a higher amount to enable you to charge more and still be affordable. Minimum value, that second component on the $3,000 penalty, is pretty straightforward. It basically means, does the plan cover at least 60% of the eligible expenses and only shift 40% of the cost to the employee, or something less than that? So in other words, when we look at things like deductibles, co-insurance, co-pays, etc., does the plan still end up paying at least 60% of the person's cost? And the answer is typically yes. Okay, now you may remember, going back to the first couple of slides, I said that the pay-or-play penalty only applies to large employers who have 50 or more full-time employees and full-time employee equivalents. That is true, but there is a special one-year transition rule for mid-sized employers, which delays the pay-or-play for them until 2016. Now, for this purpose, if you are in the 50 to 99 full-time employee and full-time employee equivalent range in 2014, you can qualify for this relief to delay the effective date until 2016 if you satisfy certain conditions. One is that you can't start laying people off in order to qualify, and since the regulations on this came out in February of 2014, they're really looking at, did you lay off people for other than bona fide business reasons between February and December of 2014. And the other thing is that they don't want you to materially reduce or eliminate health coverage after February of 2014, and you have to certify that you qualify, and it appears that this certification is made when you do your reporting under the Section 6055 and Section 56 reporting requirements that we talked about in gory detail on another webinar for David Charpentier and his team just recently. So that's where you would make that certification. Some other transition relief for larger employers because of that mid-size employer relief has the following two impacts. So if you are a large employer at 100 or more full-time employees, you get the benefit of two special rules for 2015 and 2015 only. First is that the $2,000 penalty for 2015 only applies if you didn't offer coverage to at least 70% of your full-timers rather than 95%. So the 95% threshold really doesn't take effect until 2016. You get the 1-year break for 2015 at 70%. And then the other bit of transition relief is if you are a large employer and you are subject to the $2,000 penalty, instead of backing out the first 30 employees for 2015, you can back out the first 80 employees. And again, that's really kind of in recognition of the mid-size employer relief. Okay, so how do we get our arms around this really huge mammoth requirement? Well, what the IRS has said in regulations is that we have to figure out who is full-time. And how do we determine that? And they've given us two different methods to determine whether someone is full-time. The first is a monthly measurement period. So again, what we're doing is we're saying, is an employee credited with 130 hours for the month? And how the IRS gets to 130 is what they say is that every month approximates generally 4 weeks plus a third of a week. And so you go 4 times 30 is 120 plus a third of the week is 10. That's how they get there. And under the monthly measurement period, what you would do is you'd say, okay, I'm going to measure my people every month. And if somebody ends up getting 130 hours for the month, and if I didn't offer them coverage, I have to pay the pay-or-play penalty on them unless I go back and retroactively offer them coverage back to the first day of the month. That seems extremely challenging. I really haven't had very many clients even interested in that. Instead, most of my clients are looking at the second option, which is to say, I'm going to establish what we call a look-back measurement period and a stability period. And how this one works is, I get to look back during this measurement period, and for anyone who is determined to be full-time during that look-back measurement period, then I must treat them as full-time for purposes of the subsequent stability period, regardless of how many hours they work in that subsequent stability period. So even if their hours are reduced. And while that has maybe some unfairness component to it because you're giving those folks a benefit when they're ordinarily not working on a full-time basis, it's a manageable way to get your arms around this. Now, there are two different kinds of measurement periods and stability periods. One is an initial measurement period that happens one time and one time only for new hires. And the second is what we call a standard measurement period that happens for all ongoing employees, and it happens again and again and again. I call this the Hotel California because you can check out anytime you want, but you can never leave. You have to do this on an ongoing basis. So let's first talk about that initial measurement period that applies one time and one time only. It only applies for certain new hires, not all new hires. And here's what I mean by that. If I'm a full-time employee at the time that I'm hired, meaning I'm reasonably expected to work 30 or more hours per week, then you need to offer me coverage by no later than the first day of the month following my first 3 months of employment. And also remember, you have to comply with the new 90-day waiting period rule as well, which generally requires coverage to be offered by the 91st day. There are no exceptions under this rule for someone on a short-term assignment. So if you hire someone to work on a full-time basis for 5 months, you need to offer them coverage generally after their first 3 months, even though you know they're only going to be working for you for 5 months. So that's the general rule. If I'm hired as a full-timer, you cannot subject me to an initial measurement period at the time you hire me. On the other hand, if I hire you, and at the time I hire you, I can properly characterize you as a variable hours, seasonal, or part-time employee rather than a full-time employee, that you probably could tell my Midwest accent there, then I can subject you to an initial measurement period when I hire you. So what are these people? Variable hours, seasonal, and part-time. First, let's talk about variable hour employees. A variable hour employee is someone who I think of as someone whose hours fluctuate. And that's because at the time I hire them, I can't really determine or reasonably make have an expectation as to whether they're going to truly work on a 30 or more hour per week basis on average. And so what kind of factors, and the IRS, by the way, is concerned that the employer might game them and say somebody is variable hours when they're really not. And so the IRS has said in determining if somebody's variable hours, you need to look at some underlying factors, such as who is the person replacing? Is the person replacing somebody that has been working full-time, or are they really replacing somebody whose hours have fluctuated? And another factor, what are the hours of the other employees who are working in the same or comparable positions? If they're all working full-time, that does not help your cause. Another is, how is this job advertised or communicated? Was it represented that the person was going to be working full-time? If so, characterizing them as variable hours is problematic. A seasonal employee for this purpose is somebody that might be working 30 or more hours a week, but they're not going to be working for you for a period of more than 6 months, and they're also going to be beginning their employment period with you at approximately the same time each year. So for example, if I am some type of, maybe I'm a resort business on the ocean and my high season is, April through September. That might mean that, and I employ all my workers then, and I typically hire them all in April or May, they might qualify as seasonal employees. If I operate a ski resort, that's probably not going to happen much in your part of the country, but that would be another example. And then finally, a part-time employee, and that's somebody that you can is reasonably expected to work less than 30 or more hours a week. So for these 3 categories, you could subject these folks to a measurement period before you would have to offer them coverage. And the measurement period can be a period of 3 to 12 months long. And during that period, they have to be credited with an average of 30 or more hours a week. If they're not, you do not have to offer them coverage, and you could basically ignore them for purposes of the pay or play. So let's take an example of how this would work. Let's say I hire seasonal employees in May, and I hired this particular person on May 14. Now, you can start that initial measurement period on their date of hire on May 14, but you can also start it later. For example, you could start it on the first day of the first payroll period after May 14, or you could also start it on the first day of the month after their date of hire. And I have a lot of employers that I talk to about this who really like the first of the month rule. The reason is, if I do a first of the month rule, then I can capture all of my new hires during the prior month and test them together. So the maximum number of initial measurement periods I'd have would be 12, right, rather than 365. So that's one reason for that. Now, the administrative period is the period in between the measurement period and when coverage might have to be offered. For new hires, the administrative period basically can't cause coverage to be offered later than basically the last day of the month after my anniversary date. So the administrative period in this example can go for a month, but it can't go any longer than a month. And then if that person actually had the average and was still working for me on July 15, I would have to offer them coverage on July 15. And I have to offer them coverage at least as long as the measurement period, and also at least 6 months long. So here, the measurement period was a year. If the measurement period had only been, 6 months, my stability period would only be 6 months as well. Most employers that I talk to tend to gravitate toward the 12 months. Doesn't always happen that way, but I would say most employers kind of like the 12-month approach. Okay, so that is and that measurement period happens one time on their date of hire. Then we also have a measurement period for all ongoing employees, variable hours, seasonal, part-time, and full-time. So we subject all employees to a measurement period, and we do this in order to qualify for coverage for the immediately following stability period. This is done on an ongoing basis again and again and again. So here's an example. This is a large employer. Let's assume that this is a large employer, 100 or more for 2015, so they're going to be subject to the pay or play for 2015. This employer decided to have a 12-month measurement period and a 12-month stability period. And since they operated their plan on a calendar year basis, they ended up having their first stability period be coinciding with their 2015 plan year. And I would submit to you that in general, you're going to want, if you go with a 12-month stability period for ongoing employees, you're going to want to line that up with your plan year. Plan year meaning the 12-month cycle on which you offer benefits to your employees. So what we do is we figure out what our stability period is first for this employer. It's January 1, 2015. They're going to go with the 12-month period, and then we back up from there. So for this employer, since they had a 12-month stability period that they wanted to use, then we're going to have a 12-month measurement period, and that's going to begin for this employer on November 1 of 2013 and end on October 31 of 2014. In between there, they're going to have their administrative period. That's the period for them to crunch their numbers, figure out if people made it, offer enrollment, etc. Now, you can have an administrative period longer than the 61-day period in this example, but it cannot exceed 90 days. So in this example, we couldn't have an administrative period starting on October 1. It could start on October 3, but it couldn't start on October 1. And our measurement period, by the way, can start on the first day of the month, but it might also coincide with payroll periods. So it doesn't necessarily have to be the first day of a month. Okay. So here's where, and this probably shows how old I am, but what I would say to you is that I want you to think about the initial measurement period and the measurement period for ongoing employees as there being an overlap, an intersection, or as we would say in the Ghostbuster movies, there is crossing of the streams. Okay, that's how I want you to get your arms around them. So what do I mean by that? So in my example, the two examples that we just had, we had this seasonal employee that was subject to a new hire initial measurement period that began on May 1, 2014. Well, because they were hired on May 14, 2014, and are having this initial measurement period beginning on June 1, they're already too late for that initial ongoing standard measurement period that began in November 1 of 2013, but they're not too late for the next one. And so what you need to do for this person is you need to test them simultaneously for the first year. They're going to be tested under the June 1, 2014 through May 31, 2015 period. They're also going to be tested under the first standard measurement period starting after their date of hire, which in this example would be November 1, 2014 to October 31, 2015. And here is an example, and I have to give David Charpentier credit. He was the one that mapped this all out for me to show this illustration. So if I'm a new hire, and that would be the lower line, you can see that I am going to be subject to a new hire measurement period starting in my date of hire, or the first of the month after my date of hire. And if I make it, I have to be offered coverage July 1, 2015, right? Well, then again, I'm also going to be subject to a measurement period beginning November 1, 2014. And if I make it there, I will be offered coverage on January 1, 2017. But I could make it in one place and not the other. If I make it in one place and not the other, I still get coverage under the place where I'm offered. So if I make it down in the lower line, I get coverage no matter what from July 1, 2015 to June 30, 2016, even if I don't make it up in the top line from November 1, 2016 to October 31, November 1, 2000, that should be 14 to October 31, 2015. So even if I don't make it there, it doesn't impact my ability down below. On the other hand, if I don't make it on the top line, then I get a COBRA notice on June 30, 2016. So you need to apply each one of those measurement periods separately on an overlapping basis. Now, after that, after the first year, this person is going to be measured every November through October, just like everybody else, and that determines their eligibility for ongoing coverage. A couple some special rules I want to note here. The first is a transition rule, and that is for the first year and the first year only. If you want to use a 12-month stability period but want to use a shorter measurement period, you can do that. It can be less than 12 months as long as it begins by July 1 of 2014 and is at least 6 months long. So that's a special transition rule for the first year. And so in the example so in the example I just gave you, we had the measurement period beginning on November 1, 2013 going to October 31, 2014. You could actually run that measurement period as of May 1, 2014 to October 31, 2014 for your first year and your first year only if you would like to. You could also have it start somewhere in between there, like March 1, depending on what you want to do. The other thing to think about here is that these measurement period and stability period rules do not have to be applied in a uniform basis for all employees of your organization. For example, you might want to have different measurement periods and stability periods for hourly versus salaried workers. One good example of that is maybe you pay your hourly workers weekly and your salaried workers twice a month. You may want to run your measurement periods for those two groups off of payroll dates, and so therefore the measurement periods will be similar but not exactly the same. You can also vary for employees who work in different states, or if employees are unionized versus non-unionized, or between two different unionized groups. And you can also do it on an EIN by EIN basis. but you can't do it for any other variations other than the ones I've set forth here in this slide. What if somebody transfers? If somebody transfers from a variable, seasonal, or part-time position to a full-time position during their first year, you have to offer them coverage by no later than the first day of the 4th month after the transfer. Otherwise, you're going to be looking at a pay-or-play penalty potential for that person. But what if they transfer from a variable hour, seasonal, or part-time position to a full-time position after their first year? In that instance, you could make them wait until the first stability period, as of which they were credited with 30 or more hours a week during the look-back measurement period. Now, that's not required. You can be nicer than that, but that's all that you need to do. And then if you, what if somebody is full-time and they transfer to a less than 30 per hour per week position, so they're going the other way? In general, you have to continue eligibility until the first stability period, as of which they weren't credited with 30 or more hours a week based on the prior look-back measurement period. So generally, this means that you're going to have to continue their coverage, and their medical coverage. You can terminate other benefits, but their medical coverage typically until the end of the plan year that they're in. Now, there is a special rule, though, that would allow you to terminate their coverage earlier than that, but that's only where the person averages less than 130 hours a month for 3 months in a row following their reduction in hours. And even in that situation, you have to monitor for their eligibility on a monthly basis. So if they would ever have more than 130 hours credited to them, you'd have to flip the switch back on and offer them health coverage. So this is a very special rule. Not very many employers are interested in it, but it is out there. Okay, when we're looking at hours, please do not forget that it's hours that they work and are paid, but it's also other hours. It's hours that they are paid but they're not working, for example, due to vacation. And it's also for any unpaid time off that they have, if it's due to the Family and Medical Leave Act, or if it's due to USERRA, the military leave law, or jury duty. So if you have people that take unpaid leave for those 3 reasons, you have to credit them with hours basically during those periods of absence. Now, you have to credit them based on their actual hours if you're hourly. Or if you're salaried, you can either use their actual hours, which of course some employers don't credit or have a way to track actual hours for hourly workers. If you don't, you're going to need to. Otherwise, there are equivalency methods that are available, either 8 hours for every day they work an hour or 40 hours for every week they work an hour. You can use different methods for different reasonable classes of salaried employees. But this is something that you need to get your arms around in terms of crediting. Okay, there's another special rule about rehires. What happens if I'm rehired? Well, if I'm rehired, in general, I can be treated as a new employee, but only if I'm absent from work for 13 or more hours a week. And if you're an educational employer, that 13-week threshold is 26 weeks. Now, there is a special rule called the rule of parity, where if I have a new hire who is basically gone for at least 4 weeks, and the period they're gone exceeded their initial period of employment, then I can treat them as a new hire if they come back. But in general, it's this 13-week rule. So if I come back within 13 weeks, you basically have 2 impacts here. One, you have to treat me as a continuing employee, which means I need to be treated as a continuing employee for purposes of my measurement period. And so while I'm gone, those are 0 hours that I'm credited with. And also, if I was enrolled in your health plan and I come back within 13 weeks, I generally have to be offered coverage as soon as administratively practicable after I come back, basically by no later than the first day of the month after I come back. Otherwise, I may have a pay or play penalty situation. Another rule I want to throw out here is concerning leased employees. These are employees who are leased through a temporary staffing agency. And this is any worker that I would hire through one of these agencies. The agency might call themselves a PEO or a staffing agency, a leasing company, a temporary staffing agency. It doesn't really matter what the label is. It matters what the substance of the relationship is. So if I am a large employer and I hire workers through one of these agencies and I have the right to direct and control these workers, they are considered to be my employees for the purposes of the pay or play, as opposed to the employee of the staffing agency. And this has been a frustrating issue because, as you know, many times these workers are considered for all other purposes as the employees of the staffing agency, right? I mean, they're paid through the staffing agency. The staffing agency is responsible for, withholding and payroll taxes. The staffing agency obtains workers' compensation insurance for these people, all those other purposes. Despite all of that, the IRS has said, no, 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 no. For purposes of the pay or play, these folks are the responsibility of the customer, not the staffing agency. So if this is the case and you use these people, what are your options? Well, one option is to say, I'm never going to use leased employees on a more than 30, for 30 or more hours per week. In other words, I'm only going to use these folks on a part-time basis. Another is to make sure that they never work for you for more than 90 days, because if they don't work for you more than 3 months, then, remember, you only have to offer full-time employees coverage after 3 months in order to avoid the pay or play. So that would be another way to avoid a problem. Another way to avoid the problem would be to say, gee, I'm going to relinquish the right to direct and control these employees. Now, if the people are only working for you on a super temporary basis because you have a spike in your business, you might have a real temporary situation, or these people are really more like independent contractors, then that might be a feasible option for you. But if, in fact, you're hiring these people, maybe it's a temp to hire situation where you're saying to the staffing agency, I want you to go to the market and recruit for me, vet these people, hire them, and have them work for me for, let's say, 4 months. And if I like what I see, I'm going to hire them. That's probably your common law employee. So something to be aware of. So what do we do? This is going to be a difficult situation. And I should just point out here, too, if the leased employee works for you on a substantially full-time basis for at least 1 year, at that point, you can treat the person as self-employed and you can disregard them for pay or play penalty purposes. So we're really focused on that 3 to 12 month window where they can cause you a potential problem under the pay or play. And so what can we do? Well, there is a specific exception in the regulation to address this situation. And what the exception says is, if I am a customer employer and the temporary staffing agency offers my temps health coverage through their plan, and they charge me an additional amount only with respect to those temps who actually enroll in their plan, then that will be deemed an offer of coverage by me, the customer employer, for purposes of avoiding the $2,000 penalty. So let's go back to our example of an employer that has 200 full-time employees. Of those full-time employees, let's say that 20 of them are temps. So 180 are on their payroll, 20 are through a staffing agency. Well, if I have to consider all 200 of them when I apply my $2,000 penalty test, 95% in 2016, 70% in 2015, I'm not going to have a problem for 2015, because even if I have to count those 20 people, I'm still going to pass the 70% test in 2015. That's good news. That buys me a year. But if I have to count those 20 people in 2016 and later, that means I'm only offering coverage to 90% of my full-timers. So the only way for me to get around this would be for me to enter into a contract with my temporary staffing agency to say, you're going to provide the coverage and you're going to charge me this additional amount. It's been my experience so far that a lot of temporary staffing agencies are willing to offer coverage, but a lot of them are not liking this idea about charging an additional amount only for the temps that enroll in their plan. And I think it's really has a lot to do with just the logistics of this and getting this set up systematically. They would much rather charge you an across-the-board additional amount, and I don't think that works within the meaning of the regulations. But that is something that the good news is you probably have the rest of this year to get that sorted out. But you are going to want to get your contract amended with them. You're not just going to want to take the staffing agency's word for it. And also, if you do that approach, it doesn't necessarily relieve you from the $3,000 penalty unless the coverage that the staffing agency offers is also affordable and of minimum value. And then finally, if you hire these people, please be aware that since they were your common law employees while working through the staffing agency, that time really needs to be considered and apply your waiting period. In other words, you can't start your waiting period on their date of hire on your payroll. Okay, so what should your next steps be? Well, I think first of all, you need to think about who do you offer coverage now, and do you need to offer coverage to more people in order to address the $2,000 penalty. You also need to look at the $3,000 penalty in terms of, is your coverage affordable? Under which safe harbor is it affordable? And is your coverage of minimum value? And if it's not, do you want to make any adjustments to account for the $3,000 penalty? And then you need to look at this whole measurement period, stability period issue. Are you going to have one? If you are, what is it going to be for new hires? Is it going to start on the date of hire? Is it going to start on the first of the month? How long is it going to be? And then what about your measurement period for ongoing employees? And again, mapping that out. Are you going to take advantage of that shorter measurement period for the first year? Are you going to maintain any different rules, different measurement periods for different groups of employees? And then look at measuring hours and how you're going to capture those hours for hourly folks, salaried employees, and do you have any special categories of employees that you need to address? Like, do you have employees that work for you that you don't pay on an hourly or a salary basis, where you need to figure out how you're going to capture their hours? And you need to modify your health plan and your SPD. Who is an eligible employee? Are you going to offer coverage to more than the people that you offer coverage to now? And is it going to be based on a measurement period and stability period? You don't maybe need to include the exact start and end dates of those measurement periods in your document, but you should explain the concept. And also making sure that your definition of dependent child goes until the end of the month by no later than the first day of your 2016 plan year. And then finally, you need to start preparing for the reporting that's going to be required to the IRS and to employees beginning next year. And those reports and forms are going to be drawing on the information that you're accumulating now for purposes of the pay-or-play in terms of minimum value, affordability, look-back measurement periods, etc. So this all kind of ties together. So with that, David, I think that we are ready to entertain any questions that anybody might have.
Okay, Mary, I have a comment and a couple questions myself. First of all, before I send out the slides next week, I'll fix that typo on slide 27. Apologize for that. My first question is, what if you've set up your measurement periods and so on and so forth, but you need to change your plan year? For instance, if you want to go from a non-calendar year plan year to a calendar year plan year, for instance, to facilitate having a high deductible health plan offering without any gotchas with the HSAs for the employees.
Right. There is some guidance on this. It's not quite as clear as I would like, but there is some guidance on this. And basically what you're going to be doing is you're going to be transitioning, and so it's also going to create some difficulties in terms of overlap. In other words, you're going to be having some overlap. You're going to have your old measurement period for your old plan year, your new measurement period for your new plan year, and have some folks will get the benefit again of how they did, how they fared under those two rules, and get the most favorable treatment in that transition period.
So it'd be kind of like where you have an overlap between the new hire and the ongoing.
Correct.
Okay, got it. My second question, in the situation you talked about where you have a full-time person who goes down to part-time status and you have to maintain their coverage during the stability period, what about affordability? It was affordable when they were making 40 hours a week, but now they're making 25 hours a week.
Right.
How do you handle that?
Well, interestingly, David, while that would make an impact under the W-2 safe harbor method, that would not necessarily cause a problem under the other two. The rate of pay safe harbor is based on hourly rate multiplied by 130 hours a month. And that's regardless if the person works more or less than 130 hours a month. So that might not impact affordability. Similarly, the federal poverty line safe harbor is a flat dollar amount for everyone. So it's still possible that the coverage could be affordable even though the person's hours dropped. And also, the other thing I want to mention there is if somebody's hours drop, it doesn't necessarily mean they have to be offered the same thing under the same terms and conditions. For example, if you offer 3 medical options, you might say someone whose hours dropped are only eligible for 1 medical option, or their contribution might be different, might be lower or higher. In fact, it might even be higher. But those kinds of issues are also subject to some non-discrimination analysis. But typically, since an employer wouldn't cover those people anyway, typically that at least prior to the ACA and the pay or play, typically I think many times those types of different designs could pass non-discrimination. But that's a good point on affordability.
So basically, the folks who have high, let's say, turnover between full-time, part-time, part-time, full-time, may want to consider the other safe harbors other than a W-2 if it creates too much of a problem for them.
I would agree with that. Yes, I would agree with that. I see we've
although that would be more costly to them if they're looking to minimize their out-of-pocket.
Yes, yes, yes.
Okay. I don't know if we have any questions.
Yeah, we do have a couple questions here. One was, are we measuring, and this is a very good question, are we measuring only those employees that are not offered health insurance? Very, very good question. I do not believe that you are required to measure everyone. But if you don't measure everyone, the IRS will assume that they are full-time. So, for example, if 90% of the people that work for you are salaried or hourly who are regularly scheduled to work 35 hours a week, you may not want to measure them, but you're going to then report them as full-time, you're going to treat them as full-time, and if they would have a reduction in hours in the following year, you would still treat them as if they were full-time in the prior year in terms of your measurement period and your stability period. But you could choose not to measure them. But if you don't measure them, again, the IRS will assume that they are full-time. And so I would say if you don't offer coverage to people, you definitely want to measure them. But even if you do offer coverage to people, but maybe it's not affordable or minimum value, then that would be another reason you might want to measure them anyway. Another question, do small employers who are not subject to the pay or play need to have measurement period, stability period language in their FBD? Great question. No, they do not, because you don't need to worry about those things for any year in which you are a small employer. So those were the only questions that we had that were submitted in the chat box, David. I'm sure that we might have more later.
Well, I think this has been very informative. As much as I study this stuff and I go over it again and again, I picked up a couple of things. So hopefully our audience did as well. And just to remind everybody, the slides will be available next week as well as the video. So we can go over it again and again as we forget and need to refresh our memories.
Oh, we have one more. Okay, would you suggest that we not have, I think the question was, do you suggest that we simply not have part-timers? I certainly, I think that is the tail wagging the dog, David, right? That we're saying that the pay or play penalty is going to make our decisions about whether we have part-time workers. And I'd say if you have good business reasons for having part-timers, have part-timers, and we'll figure this out. So.
Yeah, I don't want to put you in a position of answering that question, but I'll say the same thing I say whenever I do a seminar. I'm mean. If it were me, I'd have full-time, and that's it. I wouldn't deal with this. But that's me.
Okay.
Well, if we don't have any other questions, Mary, I appreciate your time. It was very informative, and we'll get the information out to everybody who registered next week, and I'm sure we'll talk to you sometime soon.
Sounds great. Thank you.